three-part question. In one or two sentences, could you finish answering the California point that Justice Gorsuch raised? Number two, finish your list on where else the state of Hawaii has flipped the presumption. You got up to littering and then you were cut off. And then number three, I have never quite understood the court's recent jurisprudence on outliers don't count. I don't know how much outliers mean.
Yeah.
Meaning at the founding, there were 13 states. I don't know how many territories at the time because I don't remember off the top of my head. But there were at least 4 states that had flipped the presumption: New Jersey, New York, Maryland, and Pennsylvania. And then later there was Massachusetts in 1790, at least for a group of islands. And then you don't have just the black codes, you have Oregon and Florida flipping the presumption a little later on. So it seems to me that you can't call all of these laws this many outlaws, outliers. And so the custom and tradition that existed was the license you had, and whether you presumed or didn't presume permission, could be flipped, correct?
Yeah, correct.
So why don't you answer the other two?
Yeah, so on the California thing, the one thing I would just add to my prior discussion with Justice Gorsuch is just, I think the overall history of what the Hawaii legislature did here was relevant. They weren't trying to attack a second-class right or something like that. They were rather trying to take Bruin seriously by opening up what counts as consent, unlike California, deviating even from the old historical laws like New Jersey in 1771, which required written consent. And I think what did the work in my friend's argument in his opening statement was this idea that 96.4% of Hawaii is now encompassed. You pointed out that dealt with sensitive places, but there is a much more fundamental problem, and it has infected this case from the start. If you read page 1 of his brief, it says, quote, it says 96.4% of the publicly accessible land in Hawaii is impacted by this law, by this law. The map he's got isn't even about Hawaii. It's about one county in Hawaii, and not even the most populous county in Hawaii, and it's a map he drew himself. So I just caution the court into saying, because if you read these briefs, it does sound like, oh, the government of Hawaii is out to get guns or something like that. Nothing could be farther from the truth. They've taken Bruin seriously, as the permit statistics I read to you say. With respect to Hawaii singling out firearms, there's statute after statute. I was reading 291-112, which is that you can't use a vehicle for habitation on private property, quote, without the authorization of the owner. There's also 633-16 that you can't remove shopping carts without the written consent of the owner. There's statute after statute like this, and the amicus briefs from the property law professors goes through and says this is true not just in Hawaii, but in state after state. They flip default rules all the time. Your last question was about outliers, and I think here our most important point is we don't think that there's some sort of mechanistic formula for how many states is enough or anything like that. We do think it's relevant that there are a number of states at the founding that do have this. This court on the sensitive places part of Bruin said legislative assemblies may be a sensitive place. There was only one state in the founding that had that. That was Maryland, and it passed 2 separate laws 5 years apart during the colonial era. That was enough to count as an analog. We certainly think the much larger number here is enough to count as an analog, because these laws actually did the same thing as what the Hawaii law does. It said, for respect to property that is open to the public, like plantations, like premises, like enclosed land. Professor Hartog says that includes seed stores, other retail establishments, akin to the kinds of things that my friend is challenging here. There is historical precedent for all of that. We think that's certainly enough to make this constitutional.
Justice Kagan.